Do the justices on the Kansas Supreme Court make new law? Yes, and here is an example. A paper by Kansas University School of Law professor Stephen J. Ware explains the problem with the undemocratic method of judicial selection used in Kansas. The question is whether judges are simply arbitrators of the law, or do they actually participate in the lawmaking process. Here, Ware explains one example. Does the state have a legal duty to control the conduct of parolees to prevent harm to other persons or property? When the Kansas Supreme Court confronted this question, it noted a split of authority in other states. For example, a Washington court held that, yes, a parole officer takes charge of the parolees he or she supervises despite the lack of a custodial or continuous relationship, and this had the effect of imposing liability on the state. However, the Kansas Supreme Court rejected this rule and said the better reasoned and more logical approach is that taken in a Virginia case which held that state parole officers did not take charge of a parolee in the relevant sense. So Kansas law on this topic was made not by the legislative or executive branches, but by the judges on the Kansas Supreme Court. In this case, the lawmaking judges did not pretend that they were compelled by the legislature or anyone else to choose one possible legal rule over another possible legal rule. Instead, the judges decided which view was better reasoned, and then made that view the law. Here, as explained by Stephen Ware, judges made new law. And judges can make new law in a way that respects conservative principles of limited government, or in a way that embraces liberal principles of expansive government. The judges are free to choose. This is why it is important who we select as our judges.